Uh, the CEO in I read that to you, 6.23, of his determination, he incorrectly concluded that Mr. Makate has not claimed a share of the revenue for as long as PCM generates revenue. I pointed out to you that in my submission, I said, well, the clear implication is for as long as it generates revenue. This is factually incorrect. The evidence in the trial court was that he insisted from day one on an ongoing revenue share. And may I add that if one reads the excerpts from the evidence and one reads Justice Coppen's judgment, Mr. Makate had experience of collecting the revenue due to Vodacom in a revenue share agreement with various vendors of airtime, and it was that which gave him the idea that, you know, he'd also, as a young man and an accountant, he would very much like to have a revenue share. Now, I'm not going to deal with 95.3. 95.4, I believe I've said that this was to reach finalization. The last thing we would want to have done is to have continued after this acrimonious litigation to hold Vodacom to account for the future. I've dealt with the patents. I've dealt with 95.3.
I think you've dealt with the duration of the revenue share in detail.
I
think you've dealt with that in great detail. Let's move on to another aspect. We've just got, I think it's about 20 minutes or thereabouts before we close for the day. Do you want to point me to anything? You said you were going to address me about the explanatory affidavit, but you haven't touched on that.
No, well, do you want me to do that now, my lady? I can. Lady, can I just... Is
it a lengthy argument?
No, it's not a lengthy argument. I'm going to point out various paragraphs to you. It may be, my lady, if you maybe it would be a good idea. The claim for interest is not going to take long, but let me deal with the explanatory affidavit. The first thing I need to do is to take you to the first respondent's heads of argument. Well, they're called submissions.
Yes.
They're in bundle 23. I'm not going to deal with them in detail because I don't want to anticipate the reply. But what I do want to point out to your ladyship is something very interesting.
Right.
That is 134-5, paragraph 6.
Paragraph 6, yes.
The CEO opposes the strikeout and contends that he has both a duty to assist the court by bringing certain facts to its attention by means of an affidavit or report. May I stop there? I don't know what new facts the CEO has brought to the table other than new arguments, and a right, as a matter of natural justice, to be entitled to an opportunity to reply and explain where his conduct of an arbitration is attacked. Now, it's going to be an interesting debate between my learned friends, Mr. Trengove and Mr. Cooper. Mr. Cooper has to use the word arbitration because he justifies this edifice here on the basis of 3 cases. The first is an English case, Port Sudan versus Chettiar, a judgment of His Lordship Mr. Justice Donaldson. Hyperchemicals, a judgment of His Lordship Mr. Justice Henry Price, P-R-E-I-S-S, and Felspun, at least a judgment of His Lordship Mr. Justice Kroon. All 3 of those judgments, I'm not going to read them to your ladyship, but I can tell you what they were about. The South African cases involved arbitrations in terms of the Arbitration Act and misconduct alleged against the arbitrators in terms of Section 33 of the Arbitration Act. Port Sudan versus Chettiar, likewise an arbitration by an arbitral panel, and there was again misconduct alleged. I can't remember the particular section of the English Arbitration Act, but in all of these judgments there was misconduct alleged. Now, what I want to point out is that in Port Sudan versus Chettiar, which is taken up by Mr. Justice Price in Hyperchemicals, what is said is that where an arbitrator's conduct is castigated as being misconduct, then he can do one of three things. One, he can do nothing and abide. Secondly, he can file an affidavit to explain the alleged misconduct. You can understand an arbitrator is accused of bias because he's seen having tea with somebody. He can explain. And the third is he's entitled to participate in the proceedings, boots and all, as a participant, as a party. Now, I'll hear, no doubt we'll hear Mr. Cooper on which of the three this procedure is. Is the CEO participating as a participant? He's filed an affidavit, filed two affidavits, and he has, of course, got counsel who's going to represent him and has filed heads of argument. The significance of that will become clearer far later. Lady, forgive me for an anecdote, but I've always believed in secular proceedings in the law, and perhaps Mr. Cooper and I could one day recite a few verses of Abide With Me together. My lady, I'm not going to go right through this now. I will try and condense it overnight. I'm only going to refer to a few paragraphs which will demonstrate to you that the CEO has in fact embroidered and bolstered his award, clearly in contravention of the principles which have been expressed in cases such as the National Lotteries case. If I may revert then...
Sorry, Mr. Puckram, just to interject, to answer your question in respect of what Mr. Cockburn is going to say in respect of where does these cases feature in paragraph 7 of his heads of arguments, he points out that the entire exercise of the explanatory affidavit was to reply and explain where his conduct of an arbitration is attacked. So clearly it's on that level that the argument goes that they have now filed an explanatory affidavit for those reasons to reply and explain where their conduct is attacked.
Well, I'm going to show you that he's gone far further than that. If you rationalize your determination, you're not explaining misconduct. But I will do that tomorrow.
I think let's call it a day, Mr. Puckram. Don't you think?
Lady,
let me just give you a lifeline, so you can go back and prepare all this, the stuff that you need to do about this explanatory affidavit. And I see Mr. Trengrove is ready to depart because he must be saying, let's call it a day, Madam Justice, please. Let me get out of here.
Madam Justice, most of this is done in the time normally devoted to sleeping, so I would be delighted to go. Thank you. I see Mr. Trengrove perhaps wants to address me, or your lady.
Okay, so Mr. Proctor, you resume tomorrow. Bright, fresh, and bushy-tailed, you'll be ready to roll. Mr. Chengrove, are you in agreement? Unmute your mic. Unmute your mic. Your mic. Unmuted.
Actually, I prefer muted, milady.
Press it. The mic. No. Press it again. Double click. We must have caught Mr. Chengrove napping. Is it happening? Okay, then we'll see you tomorrow. Okay, Mr. Kuppen, thank you so much. Sorry that you had a late start, but I'm sure you'll be ready tomorrow. Unmute your mics.
Yes, thank you, lady.
Okay, did you hear what I said?
Indeed, yes.
Sorry that you had a late start. However, I'm sure you'll be ready to roll tomorrow.
I hope so, lady. Thank you.
Right. Okay. We'll call it a day. Can we start at 9:30?
Well, indeed, my lady. Yes.
Can we start at 9:30, Mr. Trent? Okay. Can we start at 9:30?
Yes, my lady.
Right. So we'll adjourn for today, and then we'll continue and commence the proceedings at 9:30 tomorrow. Have a good evening and stay safe.
Thank you.
Thank you.
You all excused. Court's adjourned.
Yeah.